We are praying for justice. Our hope is that justice prevails and we can all use this as an opportunity to be better and do better for those around us.
So to start things off tonight, we're going to do some legal analysis of what's going on with this case revolving around Derek Chauvin. He's the Minneapolis police officer who is charged with murder and manslaughter in the death of George Floyd. And certainly is something that all of us remember. Our eyes were fixed to those 8 minutes and 46 seconds as we watch the life of George Floyd ebb away from us with his statement, "I can't breathe." So now we are finding ourselves having to breathe life into this trial to find out if people will have justice. And that is what the Floyd family is seeking. And that is what many people throughout Black America and all of America for that matter are seeking as well. Our legal team right now, we have State's Attorney Aisha Braveboy of Prince George's County. And we also have Attorney A. Scott Bolden. They're with us today, joining us from the nation's capital. A. Scott Bolden and Aisha Braveboy, State's Attorney, joining us from Prince George's County in Maryland. You know, this trial was supposed to get off yesterday in terms of making the jury selections, but it goes to the core of what people have been questioning all along. What about the third-degree murder charge? And we find it on the opening day that they are now trying to find out what an appellate judge will do with this. State's Attorney, you and I talked about this just last week. And why was that removed in the first place?
So really, I think it's an issue of interpretation of the third-degree murder statute in Minnesota. So third-degree murder is sort of a lesser form of murder. So you have first, in Minnesota, you have first-degree murder, which is the premeditation, intentional killing of someone. For second-degree murder, you have to prove intent, that the person intended to cause death or serious bodily harm and actually did cause that death. With third-degree murder, the intent you don't have to prove. So prosecutors wouldn't have to prove intent. They would need to prove that the individual acted so recklessly with a depraved heart or a depraved mind that they should have known that death would result in their actions. And in this case, obviously, death did result in the actions. So the intent issue is one that is extremely important because that is difficult to prove. It's difficult to prove intent. And so if you have the third-degree murder charge, if the jury deliberates and find that, well, he did act recklessly or dangerously or with a depraved heart, but he may not have been, quote unquote, intended to kill George Floyd, then the jury may find him guilty of the lesser crime of third-degree murder, which carries a pretty significant sentence, 25 years in Minnesota, and so that's why that charge is extremely important for the prosecutors because they want to seek tough penalties, I believe, against Mr. Chauvin, but proving intent could be difficult in this case, which is why the third-degree murder charge is extremely important.
Hey, Scott Bolden, what are you expecting in terms of jury selection? Are there any jurors who can actually judge this case or sit on this case without being exposed to this case because it was the video that was seen around the world?
Well, I think everyone's been exposed to the case. The real test in every courtroom, in every type of trial like this, is can the jurors sit as a fair and impartial juror, and notwithstanding what they've seen, what they've heard, what they've read, can they sit as a fair and impartial juror? And are they telling the truth under oath? And then if I'm defense counsel or I'm the prosecutor, do I believe them, if you will? Remember, you've got peremptory challenges. You can't get rid of any juror because of race or sex or class, but you don't have to give a reason, if you will. Although if you start to get rid of people of one race or a gender and what have you, you could be facing a Batson motion that would question where you would have to, as the one implementing the peremptory challenges, would have to defend why they were getting rid of these jurors. So if they can sit as a fair and impartial juror and they're telling the truth, then all the other attributes of how we pick juries, how we read people on both sides kicks in. It's completely unreliable. It's based on the lawyer's experience. But can I pick the very best jury for my case? Because in the end, this is going to be the most important part of the trial. Who's going to sit in judgment with that video out there and with the defense making an argument that the fentanyl in George Floyd's system actually caused his death? It wasn't the knee on the back of George Floyd, which goes to the core issue of not just intent, but of criminal exposure for the defendant.
Yeah, there again, it goes into a situation wherein it could be a case that goes all the way to the completion and a sentence is not a sentence, but a jury verdict comes out, and it could be completely different what the American public may or may not expect. We've seen it in cases like this that have had a lot of racial undertones and overtones, particularly in this case, where it's caused a lot of heartbreak and agony with the results of that. Now, I don't want to predict what's going to happen, but I'm going back to Rodney King. We saw Rodney King beaten by several police officers, and we watched the jury return a verdict of acquitting those police officers involved in that, not guilty. So what does a prosecutor face in this kind of trial where there apparently is a burden of proof upon them, even though they have the video right there?
Well, look, I mean, all police officers have a right and a duty in many cases to use force, and they are allowed or permitted to use force that is objectively reasonable. And that is the standard that is set forth in Graham versus Connor, where, these types of police involved use of force cases are judged by. So every case is based really on the fact pattern of that case. And in this case, you had an individual who, by all accounts, was not a threat at the time that the continued force was used. So even if, let's say, for the sake of argument, he resisted initially, and so there was some level of force that was permitted by the officers. Once that individual no longer presents a risk, once that resistance has ended, then the officers have a duty not to continue to apply that level of force because things could happen, like someone could actually die.
We'll be right back.
My concern is that the outcome is going to be the same as it's always been, a cop being found not guilty saying he was just doing his job.
The issue, though, for prosecutors, I have to tell you, in charging these cases is how to charge it, understanding that officers do have certain rights and duties and can use force, including lethal force, under certain circumstances. When I look at this case, I don't believe this is a case where lethal force was appropriate, but the question is, was the force used actually lethal force? Yet it did cause the death, but was that the intent of the officer, or was the intent something else? And that's why the difference between the second degree, third degree, and the manslaughter charges are extremely important. Sometimes in these cases, going back to what you mentioned, Mr. Wright, about fentanyl and other things possibly being in the system and making those kind of arguments, sometimes prosecutors choose to also charge first degree assault, because what that does is it gives more options in terms of the types of charges that the jury can consider. So let's say the jury found, and I'm not saying that they should, but let's say in this instance, the jury found that the action of the officer did not in fact cause the death because the death was caused by something else. I'm just saying that for the sake of argument. But if it is still believed that the officer's actions were excessive, he could still be charged and convicted of a first-degree assault, which in many states carries a pretty significant number of years. Very close to, in general, very close to what a manslaughter charge would carry in most states. So having options are important. However, sometimes prosecutors choose not to charge those lesser offenses because they don't want to give the jury options of finding the defendant guilty of a lesser offense, which might carry less time than the greater offense. So it is a calculation that prosecutors go through depending on how strong the evidence in their case is and what they think they can prove.
When you look at a case like this, a case that caused so many people around the world to protest with Black Lives Matter, Black and whites protesting out on the streets throughout America and throughout the world, whites even raising their concerns, waving signs saying white silence equals more violence. This case is bigger than what's happening in Minneapolis, yet it still has to be balanced by the scales of justice. So tell me, if you will, how you view this case, looking at it from the outside, but yet knowing the people on the inside who are prosecuting this case.
Well, the prism you're looking at, that most people are looking at through this case, or the prism they're looking at the case through, is the criminal justice system, racism, police brutality, white privilege and white racism that wear guns and badges and flags on their uniform is all on trial. Arguably, it is, because so often the African-American community has seen young men and young women brutalized by the police, killed by the police, only for the criminal justice system and a jury to let them go. Because police officers are one of the tough groups out here to convict. They're the last line of defense between chaos and community. And whether you're black, white, yellow, or brown, it's tough to get a jury to say that that officer engaged in criminal conduct, whether they're black or white, because their purpose, their intent for being there is not to maim or to murder, but to keep the community safe. That psychology, that dynamic in the minds of a juror or all of us will ring true. And it's tough to break that thought process. But the reality is that if there's criminal conduct, whether they under color of law or not, they've got to look at Chauvin as a defendant, if you will. And in looking at him as a defendant, the whole concept and precept of what you're looking for in a jury and what the case is going to represent and stand for is turned on its head. The defendant is actually the police officer. The police officer is usually a witness for the prosecution. And so what you're looking for in a juror, what you're arguing to a judge, is completely reversed and inversed. He will be believable, but a couple things to look at and watch. This video is very powerful, if you will, at first blush. If I was the defense counsel, regardless, and I would probably never be a defense counsel defending Chauvin in this case, but if I were, I would run that tape over and over and over again. I would break it down frame by frame, and in each frame argue to the jury that each frame suggested some resistance. Each frame suggested that the knee on the neck was not actually killing George Floyd, that before the knee on the neck, he was acting erratic, and it was because of the drugs. But for the drugs, he would not have died. The prosecution is going to argue, but for the knee in the back, he would not have died. This is going to be a really close call, really difficult case to prove. And I think the prosecution has undercharged it, if you will. What do I mean by that? I mean that usually you get the lesser included, like a manslaughter or third-degree murder, after all the cases, all the facts have been presented, and then there are motions to put in lesser included because the evidence has supported the lesser included or first-degree assault, if you will, as my colleague said. Here, they went in and indicted the defendant for all three. It suggests they don't have a lot of confidence in the case, or that they have facts that they're going to present that could go either way, that they really don't have a strong case. I could be wrong about that, but if your case has an inferiority complex where you're pleading and you're indicting for lesser included, you're looking, or you're telegraphing that I've got a tough case ahead of me.
Oftentimes, because prosecutors are ethically cannot try their cases in the media. A lot of the information, the evidence, the
Very
weight
true.
of the evidence,
Yeah.
the general public doesn't know, but those prosecutors know. And so oftentimes they charge based on what they believe they can prove beyond a reasonable doubt. And they don't want to leave out charges I've never tried a case in Minnesota, so I'm not sure what the rules are there. But in terms of adding charges or having the jury consider other charges or lesser charges at some point, I don't know what the options are for juries out in Minnesota. So I think here, I think the prosecutors are being cautious. I think they're charging a very serious charge, which is the second-degree murder, but they're also giving other options, again, that carry significant time. I mean, the third-degree murder carries 25 years, which is pretty significant. Obviously, the manslaughter carries up to 10 years, which is, a less in terms of the amount of exposure in terms of time, but it is still pretty significant. But that 40-year sentence that the second-degree murder carries in Minnesota is really, I think, what the prosecutors will be aiming for. But I think they just want to make sure they're covering their bases. And again, I'm going to give a little deference to them because we don't know all of the facts. They do. And I have confidence in AG Keith Ellison and his, ability to determine what is appropriate moving forward in terms of this case.
We're coming back with more after this.
Pleading manslaughter, it means you weren't intentional in killing someone, and pleading murder, where you have a higher level of intent, seems to be inconsistent with one another. Either he intentionally did it or he didn't. Either it's murder or manslaughter. Those are on opposite ends of the spectrum. How do you reconcile that as a prosecutor and then demand a murder charge be presented to the jury and ask the jury to convict him on murder and or manslaughter?
Yeah,
that happens. That happens all the
time. That happens all the time in both cases involving law enforcement officers and cases involving civilians. So it is not uncommon for prosecutors to charge everything because, again, they have to prove beyond a reasonable doubt every element of the charges that they set forth. So they may fully believe that this case merits a second degree or in some cases a first degree murder conviction, but the trier of fact is the jury. And so you have to also give weight, obviously, to the evidence and what you believe you can prove. And if you believe that there is some concern regarding being able to prove intent beyond a reasonable doubt, then you would be really doing your community a disservice not to charge the manslaughter or the third degree murder in the case of Mr. Chauvin, because that does not then give the jury right away an option of finding him guilty of a serious offense without, intent having to be proved. So I don't disagree with you. And I do think that, it does seem to be kind of at opposite ends of the spectrum. But again, it's really about what the jury determines that the state has proven beyond a reasonable doubt. That's a very high burden to meet.
Very much so. But I still think it's inconsistent. It's going to confuse the jury. And I can tell you in New York and some other places like Illinois, where I am barred, and I was a former prosecutor from New York, the law and the judges just wouldn't allow you to plead like that. Either it's an intentional murder or felony murder or not. Either it's manslaughter or not. And if it rises from the same common nucleus of facts, then that indictment would be thrown out for inconsistency. Either he did it intentionally or he didn't. Minnesota clearly is a different jurisdiction, and we'll have to see how the jury convalesces or how the jury handles or manages those what appear to be inconsistencies. But I agree with you. If they can do it in Minneapolis, let them do it, and then let the jury figure it out.
And, you know, that could be problematic towards the end when the jury has to figure it out. They'll be, you know, I can imagine them sending a lot of questions back in to the
Yeah,
be-
yeah.
during their deliberations. But the other thing that I take from all of this, from what both of you are saying, is that what we're finding out in this particular case in Minneapolis related to Derek Chauvin, who, of course, is indicted and charged with murder and manslaughter at this current juncture for the death of George Floyd. It seems to me that the prosecution has been trying to cast a wide net that's multi-layered, perhaps interconnected and interrelated in some way of making sure they come out with a conviction. If that doesn't happen, you know, what do you think the outcome would be in the public's eye? Will justice have been served in the court of public opinion?
Well, I think the court of public opinion has already kind of weighed in. Some people think that he should have been charged, with first-degree murder, right? So the fact that the highest charge is second-degree murder for some people is a miscarriage of justice. And then when you look at you know, the difference between second-degree murder, which he could be found to have been, or he could be convicted of, or the lesser offenses of third-degree murder or manslaughter. If he's convicted of anything other than second-degree murder, some people are going to be upset about it. And if he's convicted of nothing, trust me, I think that we'll have, you know, unfortunately, more unrest. But I think psychologically, in the minds of not just Black Americans, but all Americans, I think the question really is, do we feel that our justice system respects Black lives? I think that's at the bottom line. If he's convicted of nothing, I think that it will be very hurtful to people. I think that there will be a sense of anger, but mostly that will grow out of hurt, that they will feel like, again, you know, America in their minds have shown us that Black lives really don't matter. And that psychologically can be very, very damaging at a time when we're trying to move our country in a much better direction. I know that Mr. Bolden was a big part of that. So I want to thank Mr. Bolden for all his work in getting us to where we are in terms of politics. But in terms of how we feel about ourselves and how we feel that this country views us in so many ways is on trial as well.
Yeah, if I may, I think my colleague is absolutely correct. It'll be disappointment, but and loss of confidence in the criminal justice system. And the Supreme Court has said, picking a jury and people believing, the community believing in the criminal justice system is vitally important. But secondly, it'll put a lot of pressure on our federal elected officials in the Senate side to pass the George Floyd bill. The House has passed it already. It has major reforms in it. It blocks chokeholds. It changes the standard from reasonable force to necessary force. It takes away or does away with bail and engages in bail reform, and just a litany of things that people of color and all of us as Americans have complained about based on how police officers have treated African Americans. They simply don't see us. At least they don't see us a lot as human beings, because you can see how they treat us, and then they treat animals oftentimes. I'm not talking about all the police officers, but if you tolerate bad behavior in your police force and it's part of your culture, you're complicit in it, even though you're not being accused directly. I'm sorry, it's a hard standard, but too many Black men and women are being abused and killed at the hands of guns and people wearing uniforms and badges, if you will. And so I think there'll be even more pressure to pass that bill in the Senate and to have the Biden administration sign it and then implement that reform in every state. You know, at the feds, this is a federal law that legislation will be passed, but then there'll be pressure on every state house and every governor to implement it and to pass their own measures. That's super important, because the only way you're going to stop the killing fields of Black people in their communities at the hands of police, it's multifaceted, but it's also about who we're giving guns and badges to as an initial step. That's got to be looked at and reviewed. And why are we teaching police officers that this is an us versus them mentality. That is, it's the police force versus the Black community or any community and stuff. It simply has to stop. They're there to protect and serve. And so many times when you shoot these shootings, these police shootings, they're not there to de-escalate or to protect and serve. They seem to escalate it and really put energy into using force when it is unnecessary. And so Supreme Court has said you can't use violence or you can't shoot somebody who's a nonviolent fleeing felon on the Tennessee v. Garner. You can't, and yet we continue to see that Supreme Court decision violated at many levels in many states and many cities. Disappointing, but there's hope. And this, whatever the verdict is, this will spur hope not only for reform or at least some justice, either in this trial with the verdict or afterwards with that George Floyd bill passing.
Coming back with more of my discussion with State's Attorney Aisha Braveboy and Attorney A. Scott Bolden. You know, both of you, A. Scott Bolden and State's Attorney Aisha Braveboy, have been talking about the case as it relates to Derek Chauvin and his trial in the death of George Floyd. Stepping beyond that, though, we've heard other things seeping through in your commentary about what's going on. I've got to ask you, you know, based on what we've seen over the past year, the Breonna Taylor case, which shocked a lot of people, of course, Ahmaud Arbery, now George Floyd, and the list goes on, sadly, and the racial divide that we have in this country, and that attack on the Capitol on January 6th, where we saw law enforcement overwhelmed by white nationalists, domestic terrorists, as they've been defined by the FBI, and
insurrectionists,
security,
seditionists,
insurrectionists, attempting a coup of this country, and we still see that there is a racial division in this country, and we also know that there's a threat against Black Americans and people of color in this country from these insurrectionists and white nationalists, and it still goes on social media and everything. State's Attorney, you work in this realm. You're trying to make sure that everybody is protected, Black, white, yellow, brown, whatever. What are we up against in this country that has failed to actually address the systemic issues? And now we have a president stating that we must address these systemic issues.
Yeah, we're up against white privilege, because even if you look at how the insurrectionists are treated, they're treated very differently than what we know Black and or brown individuals, how they would be treated if they were in a similar circumstance. The level of deference that have been given to some of these people who've committed treason against our country, who beat police officers, who engaged in mob violence, who threatened, you know, not only members of Congress, but also the former Vice President of the United States. We're talking about people who meant business. They came to the Capitol to do destruction. They did do destruction. They continue to be a threat to our members of Congress, to our Capitol. Yet you hear things like individuals who are, you know, moved from one prison to another because of their dietary preferences, or individuals who want to go on a vacation with their colleagues, and so they're permitted to go, and individuals who are charged with lesser offenses. And you even hear prosecutors talking about, well, should we charge everyone? You know, this might take up a lot of time. To me, that does not show the level of seriousness that this event and that these individuals, the threat that they pose. And again, I believe, quite frankly, it's because of that privilege. It's because they are looked at very differently, even by prosecutors, even by law enforcement officers. They're still considered different than those of us with Black skin or brown skin. And so until we grapple with that issue, you know, Black and brown people will never feel equal. We'll never feel like we're completely safe and that the laws apply equally to all of us if you can't even treat insurrectionists people who threaten our very democracy, took over our, if you can't treat them with the level of seriousness that you would treat someone who was participating, let's say, in a non-violent protest, which we saw happen, that people were arrested even at non-violent protests. If you don't see that level of seriousness, it's hard for a lot of people to believe that the system is truly equal.
Mr. Bolden.
Oh, my colleague said it all. I would only be adding to what she said, but we've got two criminal justice systems, one for rich, one for poor, one black, one white. And until you have race reconciliation dialogues, until our brothers and sisters who don't look like us are prepared to lock arms with us and move forward and say, this is not our America. That's what you saw on the front lines of the George Floyd protest. Black folks and white folks, much like in the 60s with the civil rights movement, saying enough is enough. This is not my America. We need our brothers and sisters who don't look like us. I don't need them to be anti-racist. I need them to be anti-racism, right? I need them to stand up when they see it and it rears its ugly head and say something, do something, invest some money in something, say no, denounce it. And instead of just walking away from it. Until that, and we have race reconciliation dialogue about slavery and Jim Crow, until this country apologizes, simply apologizes. I know the House of Representatives in 2008 apologized, but this government, this U.S. government apologizes for what they put Black people through from slavery and 400 years forward, until they discuss and get serious about reparations and the $13 trillion that arguably the experts say they would owe Black America as ancestors to slavery, until white privilege is recognized as the first cousin to white racism, right? Until classism and racism are taught equally in our discussion, we are going to continue to have two Americas, and we won't be able to have one America. And remember, 2043 is coming, when the statistics show that we will be a country of color. That's what this anger and voter suppression and all the conflict is about. 2043, when the majority of African Americans or people of color will be the majority in this country, and people that don't look like the three of us are scared and projecting how they anticipate being treated based on how they've treated us over the years. I'm no social scientist, but I can see it. And so until we resolve those issues and we get serious about it, this government, private sector, all groups, we're going to continue to have this conflict and this division, and people aren't going to feel safe. I don't feel safe in this country. I feel safer with the Biden administration, but the Trump administration was really scary for people of color and immigrants. We've got to face that and be honest and have an honest dialogue rooted in accountability, forgiveness, but a plan for moving forward.
Back with more after the break.
If I can chime in, I think, A. Scott Bolden is certainly correct. And pretty much, I agree with pretty much all that he has talked about, mainly because we both went to Howard University School of Law.
I knew she was going to get that
very
in
well.
there.
Of course, I had to shout out HU, okay?
But if all that's true, what's the but? Where the but comes? What's the but? I'm with you. Go on.
and
all righty.
I think it's really important that though we feel safer and we have greater hope under the Biden-Harris administration, that we must still be vigilant, because right now we have a very, I think, smart thinking House. The Senate, however, has not acted on some of these very important pieces of legislation. And, I get the fact that there's some, institutional understanding between Republicans and Democrats, but bottom line, that 60 vote rule to move and pass legislation cannot and will not work, because if we're not able to get the George Floyd Justice and Policing Act passed through the Senate, that will be a huge disappointment to the millions of people who supported, who gave money, time, and everything else to winning Georgia, right? We wanted to win Georgia so that we could pass legislation. And I believe that we have to, and the Democrats in Congress, especially in the Senate, have to just step up and do what needs to be done. They are never going to get the Republicans to agree to any really smart, progressive legislation to move us in a direction of inclusion. That's not going to happen. So we shouldn't have even sold the story about, you know, winning Georgia so that we could pass this bill if we didn't plan to do what we needed to do to pass it. And so I just ask everyone to call your Congress, your member of Senate, sorry, your senator, including Joe Manchin out of West Virginia, and let them know that our expectation is that the George Floyd Justice and Policing Act will pass, that our Voting Rights Acts will pass, that every progressive, smart, important piece of legislation that we sold the American people on would get done if we had the majority in the Senate. Those pieces of legislation need to flow through that Senate so that we can move this country in a better direction.
I want to thank both of you. And I would just add to your point, State's Attorney, states that have lost big time because of the power of the black vote, stop trying to put it back into a voter suppression and allow people to continue to vote with the laws that you've already put into place. And now you're trying to change them again. I just appreciate both of you, the brilliant work that both of you are engaged in. And I hope when people look at you and they're young, that they want to be in the game, not in the game for the, like, look at me, I'm a prosecutor, I'm a great defense attorney, but look at what I can do to help my people.
No doubt. Kelly, if I could just jump in real quick, I want them to be better than me and Aisha. My dad's I'm a second generation lawyer. My dad's a retired judge in Illinois. And I remember walking across Howard Stage and I remember telling him that I was going to be a prosecutor, criminal defense lawyer, just like him. He says, I want you to be better than me. In fact, all of us need you to be better than me and all of my contemporaries. And I've never forgot that. And he's right about that. I want our young people to be better than me.
Well said. Thank you both so much. Coming up next, we'll talk about some optimistic news on the war front against COVID-19. Next.